Australia's family law system.
Question is the document be noted, and I call the member for Warringah.
Thank you, Mr Deputy Chair. I commend to the House the third interim report and the final report tabled on behalf of the Joint Select Committee on Australia's family law system, of which I am a member. In doing so, it is important I call on the government to actually act on these reports and the two reports that came before them from the committee. Don't let these reports sit on the shelf like so many similar reports from previous inquiries. It should be noted that there has been 67 different inquiries into the Family Law Act since it came into effect in January 1976. Unfortunately, there is a history of successive inquiries identifying similar systemic problems with our family law system and successive governments being unwilling or unable to make the necessary changes. When this inquiry was first announced at the end of 2019, I was sceptical that this was actually to implement real change and not just a political stunt. My concerns in relation to how this committee might be used and the process were real, because these are real people's lives. People are incredibly impacted by breakdown of family relationships, and they are turning to this inquiry for change. They're turning to the government for implementation of recommendations to feel that there can be progress in such a distressing area. As previously, before coming to this place, being a family law barrister, I have absolute experience of how distressing this area of law can be. It goes to the absolute core of people's lives, and having acted for both sides, for men and women, both parties, in property and parenting proceedings, it can be so distressing. And so this needs to become a bipartisan, and there needs to be political will to implement these changes. The reality is, in modern society, sadly, 40% of marriages end in divorce. And while many of those separations are conducted fairly and amicably, there are still many Australians who rely on the family law system to settle their divorce or separations and resolve disputes over property and custody of children. And most of us know someone who has gone through this, either separation or through the family law courts. And to various degrees, this process can be adversarial, confrontational, emotionally unsettling, financially crippling, and life-changing. If there's one thing we can never get back, it's time. And it is one of the major problems with the system. So for that reason, it's imperative that our family law system not only be functional, but it needs to be fair and well-funded, because they all go to that question of time and the time it takes for disputes to be resolved or determined. And so it is so important that the government take note of these recommendations. Over the course of the inquiry, we received more than 1,700 submissions, the majority from individuals detailing their incredibly personal cases and experience. And I thank all those who provided evidence and submissions to the inquiry. And despite the challenges of COVID-19, the committee held 13 public hearings and 13 in-camera hearings. And I'd like to thank all the people on the committee, but importantly also the Secretariat, for their tireless efforts in providing logistical and administrative support to the committee. The terms of reference for this inquiry were far-reaching, and on the whole, I feel they've been addressed by this inquiry. The key issues identified were the costs associated with the family law system, the adversarial nature of the family law courts, and whether we should move towards a more inquisitorial model, the issue of distressing delays in the current court system, the role of family consultants, expert witnesses and independent children's lawyers, enforcement and contravention of family law orders, and family violence, because it is considered in family law proceedings how it interacts with the family law system and the family violence jurisdictions. The first interim report canvassed the various themes and issues raised in evidence received throughout the first 12 months of the inquiry and was tabled in October 2020. The second interim report detailed the committee's conclusions and recommendations in relation to the family law system and was tabled in March 2021. The third interim report deals specifically with the issue of Australia's child support scheme, which emerged as a dominant issue during the inquiry. We expanded the inquiry with the aim of focusing specifically on child support scheme and its interaction with the family law system. The committee's goals were twofold. Firstly, to allow for a better analysis of the existing evidence, and secondly, to provide an opportunity to gather additional evidence through a further inquiry and better question key government agencies and stakeholders. The child support scheme is vital to society. It is a social policy, noting it supports over 1 million children and it involves approximately 1.25 million parents. There was a broad range of participants who were generous enough with the committee to provide their personal experiences with the child support scheme. And it's important to remember that the overriding objective of this scheme is to ensure that children, the innocent parties in all family breakdowns, receive a proper level of financial support from their parents. The overriding duty is that parents owe a responsibility they're financially responsible for children, and that can never be forgotten. The committee's recommendations also aim to improve the general operation of the scheme and the experience for both the payer and payee parents. Less than 40% of cases involved payments of $5,000 or more per annum, and that approximately 30% of cases actually had amounts payable of $500 per annum or less, which does make me question how those children are actually managing on such small supports. Importantly, the committee was also advised that the median child support payable under the formula was only $3,354 per annum, or approximately $65 per week, which really raises some questions of how well the formula is actually working. And one of the key themes identified by the committee was the general accessibility of the scheme. And that's why one of the recommendations is for the government to provide adequate resources to Services Australia to allow it to enhance child support scheme services and how it should work better with the courts. In particular, there was a recommendation of more consultation and more transparency. The Australian Government needs to reconvene regular meetings of the Child Support National Stakeholder Engagement Group, and in particular recommended that there should be a meeting before the end of 2021 and that group should meet at least twice per year, and the group should publish minutes to promote accountability and transparencies. Participants in the scheme want to know the scheme is being looked at, reviewed and assessed. Location of child support officers in the family law courts. There needs to be a better conjunction between the two schemes, with the scheme with the courts, to ensure that there is proper reference and that they are working together. One of the more shocking aspects was actually raised was the child support payment debt and government guarantee. So Australia currently has $1.6 billion of child support debt. And the report powerfully states that this is equivalent to stealing from children. So urgent action needs to be taken to reduce the existing child support debt levels and to promote the ongoing prompt payment of assessed child support, because those children need that financial support while they are children. So recognising this increasing level of debt and the negative impact it will have on children, the committee notes that a number of submitters proposed a guarantee mechanism to ensure payments are made to the payee parent irrespective of the parent's compliance. Essentially, a framework that would provide that it would become a debt to the government, which can be pursued accordingly through government services. The committee felt that this suggestion has merit because the government is better placed to recover outstanding debts compared to individual parents. Of course, the question of financial abuse and family violence featured prominently, because we must never underestimate financial abuse. That is the withholding of child support payment, which creates, and it needs to be recognised as, financial abuse. There were in all many recommendations, and I urge all those that participated to read the report in detail and to better understand where these recommendations can be. It really is important that the government engage with these issues. Ultimately, there were many questions of mental health that were raised because of the pressure of this system. So I would encourage anyone to seek help with Lifeline, Beyond Blue, and those numbers can be found. And ultimately to seek help that a breakdown of family relationship not be exacerbated by the system.